Hello, I'm Neha from Project Finder. This is a research project funded by the European Union that offers free and open methodologies, tools, and training on fairness, accountability, transparency, and ethics of AI-based human recommendation, or in other words, online hiring processes. This video is a brief summary of our training course and of the fourth module, which is an introduction to legal rules at the European Union level to regulate anti-discrimination in online hiring. In this module, we'll provide a brief overview of European anti-discrimination law that will outline the legal framework regarding discrimination in recruitment and employment. 2, we'll explain the relevant provisions of the General Data Protection Regulation, in short, the GDPR, as this impacts the legal framework for data collection during the online hiring processes. And 3, we will briefly outline the European Commission's proposed legislation, that is the AI Act, that will have an important impact once it is adopted. The right to non-discrimination is included in many fundamental rights of EU conventions. The latest confirmation of this right can be found in the Charter of Fundamental Rights of the European Union of 2000. Thus, the EU has long recognized that equal employment is a force of social cohesion, dignity, and equality. Its earliest non-discrimination directives were concerned with employment, and there are several directives that prohibit forms of discrimination in the labor market. The EU laws impact its member states in different ways. For instance, a regulation is a binding legislative act that must be applied in its entirety across the EU. A directive, for instance, is a legislative act that must be implemented in national law. In practice, companies apply the national law based on the EU directives. In recruitment process, the EU directives protect people against discrimination on the following 6 grounds, also called the protected characteristics, that is, religion, disability, age, sexual orientation, ethnicity, and gender. There are 2 forms of discrimination outlined in the EU law, direct and indirect. Direct discrimination occurs, for example, when a company says it will not recruit employees with a certain ethnicity. From a legal perspective, the intent to discriminate or the existence of prejudice are irrelevant to direct discrimination. What matters is that 1, a person is treated less favorably, 2, when compared to how other persons in a similar situations are or have been or would be treated, and 3, the reason for the less favorable treatment is a certain characteristic that falls under the protected grounds, example, ethnicity, gender, or religion. It would be possible to make algorithmic systems that discriminates directly. For instance, the developer of an algorithmic recruitment system could ensure that the system never selects an application from somebody with a certain ethnicity or born in a certain country. Indirect discrimination is the second category of prohibited discrimination. Roughly speaking, indirect discrimination occurs when a practice is a neutral at first glance but ends up discriminating against people with a protected characteristic. Both direct and indirect discrimination are banned, but some forms of indirect discrimination can be justified measured to if the aim is legitimate and the practice is proportionate. For example, a women's clothing brand can recruit only women as models for its advertising without breaching the legal ban on discrimination. The General Data Protection Regulation, in short the GDPR, became effective in 2018 to better protect people's data. It foresees purpose limitations. This means that personal data should only be collected for specified, explicit, and legitimate purposes and not further processed in a manner that is incompatible with those purposes. This is aimed to enable lawfulness, fairness, and transparency of data use. The GDPR law grants rights to the people whose data are being processed, who are called data subjects, and imposes obligations on parties that process personal data, also known as data controllers and data processors. To achieve this, it sets out principles in the European law around data minimization, data integrity, and confidentiality, as well as storage limitation and accountability for parties that process the data. The GDPR's personal data definition is broad and moves much beyond such obvious personal aspects as a person's name or address. Personal data means any information relating to an identified or identifiable natural person that is the data subject. Because the personal data definition is so broad, deleting a name and address from a data file, such as a CV, is almost never enough to anonymize the data. The GDPR has extra strict rules for special categories of personal data, which is data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, or trade union membership, and genetic data, biometric data for the purpose of uniquely identifying a natural person, data concerning health, or data concerning a natural person's sex life or sexual orientation. Hence, when we go back to the categories that are protected grounds of discrimination, in principle, the GDPR prohibits the use of data about somebody's ethnicity, religion, health, and sex life. Other personal data that are not listed in Article 9 are not special categories of data. In particular, data on gender and age, there are also grounds of protection. It should be noted that some categories are fluid in society. Thus, the legal definitions are not always clear-cut. For example, asking someone if the person is a female, male, or has another gender identity, such as non-binary, can also be associated with asking if someone belongs to the LGBTQ+ community, which is associated with sexuality. The GDPR provides 10 exceptions to the prohibition on processing special category data. Exceptions are related to the nature of the data controller. For example, hospitals are allowed to process personal data about health as well as the public interest or context of the data. A general overriding principle that is important for data collected in online hiring is that data subjects can override the ban by giving their explicit consent for the processing of their special categories of data and other personal data. When it comes to consent, GDPR introduces strict requirements. Article 4 defines consent as follows. Consent of the data subject means any freely given, specific, informed, and unambiguous indication of the data subject's wishes by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. Thus, the elements of consent definition are 1. An indication of wishes, 2. Specific and informed, and 3. Freely given. Guidance by the European Data Protection Board shows that consent is typically not sufficiently free if an employer asks an employee for consent because of the imbalance of power. Job applicants, that is, future or prospective employees, can rarely give valid consent to, again, because of the power imbalance. In our module, we'll go deeper into the legal issues of data processing by AI in human recommendation. Now we turn quickly to the AI Act. The AI Act is a horizontal regulation for the development, placement on the market, and use of AI systems in the Union, irrespective of whether those providers are established within the European Union or in a third country. The AI Act is being negotiated by the European Parliament, the European Commission, and the European Council. The negotiations are expected to last until the end of 2023 or beyond. In the AI Act, AI systems are classified among 4 different categories of risks: unacceptable risk, high risk, limited risk, and minimal risk. AI systems in employment, workers' management, and access to self-employment are considered high risk. These include AI system intended to be used for recruitment or selection of natural persons, notably for advertising vacancies, screening or filtering applications, evaluating candidates in the course of interviews or tests. Providers of high-risk AI systems must comply with a list of obligations which is mentioned in Chapter 2 of AI Act as well as on Chapter 3, which is currently also a part of political discussion. More information is available for this module on the description of this video, including various ways of accessing the entire course.